Did Donald Trump just get a win at the appellate court in New York about his $500 million or $463 million civil fraud judgment? Is he the winner in that appeal? Not exactly. I know the headlines are Donald Trump gets out from under a $500 million disgorgement fine. Maybe. But wait till I tell you what really happened. Follow me. 5 justices. You have to have a majority. This is the first appellate division in New York. It's the appellate court that sits over New York, sits over Manhattan. The majority, 4 out of 5, found that Donald Trump and those in his organizations committed fraud, and that he's likely to commit fraud in the future. That the case that was brought under a unique set of powers in New York by Letitia James, the Attorney General, was properly brought. It was timely brought. She had the power to bring it. The judge had the power to enter the injunction and to find fraud, and fraud was rightly found. However, 4 out of 5 also didn't agree on the amount of the fine. 2 of the 4 said there should be no fine at all. And when we say fine, we mean disgorgement. And when we say disgorgement, I mean it's the amount of money that's calculated that you received through fraud or other illicit or illegal means. We call it ill-gotten gains. It's exactly what it sounds like. You got something you shouldn't have gotten, and now you got to give it back. That's called disgorgement. Okay. So when we talk about the amount of money, it's not damages. It's not the amount of money you got because you were injured or breach of contract or defamation. That's damages. This is disgorgement. That's all we're talking about. And so Moulton and Renwick, they said, no, the injunction was fine. That solved the problem. And the fine, the disgorgement, we don't think you calculated it right. It's too hard to calculate. That's it. The Rosado and Higgett, they said, no, there should be a fine, but it needs to go back for a new trial to calculate. Rosado, Higgett, Renwick, and Moulton got together and said, why don't we just certify this issue and let it go with the parties up to the next level of appeal in New York, which is the Court of Appeals. There's no Supreme Court in New York. There is a Supreme Court, but it's the trial court level. And so that's what they did. They certified basically the final judgment here. Out on a limb was Friedman. Friedman was like, why are we here? The case should have been dismissed. There's no fraud. There's a selective prosecution. There's no amount of money that should be calculated that's being properly calculated here. The case should have been completely dismissed. Forget him. I was worried about him. And a number of times he issued emergency injunctive relief when he shouldn't have, or temporary restraining orders that were reversed by the rest of the panel. So he's an outlier. But even the 4, that's why it's so confusing. You've got 3 separate opinions. No one got a majority vote. Like if just Rosado and Higgett had slid over with Moulton and Renoir, at least it would have been 3-1, 3-2, whatever. That didn't happen. But while there's fraud established, while there's liability established, while it's a timely case, and she did everything right, there's this fight over the money. And the reason that Moulton and Renwick said that they could not agree with the money at all, or the amount of money, is under the 8th Amendment excessive fines under the U.S. Constitution. It's also under cruel and unusual punishment. Excessive fines is another one. And they just thought that the calculation came out so excessively, although I don't really see it that way. When you're a 7 billionaire, 2, 3, 4, 5 billionaire, like Trump claimed he was, to lose $363 million plus $100 million in interest, I mean, so what? They even thought going into this matter that some amount of money must have been appropriate because they forced Donald Trump to put up a $175 million bond. I mean, they didn't say zero, and this is the same appellate panel. So a lot of this doesn't make sense. I think what they could all agree on is fraud by Donald Trump and those around him. Proper use of the statute by Letitia James, which is important. I'll tell you why in a minute. And the injunction that was established. Remember the injunction, or I'll tell you, firsthand. The injunction, there's a court-ordered monitor who's a former federal judge, Barbara Jones, who's the not the receiver, but the monitor over all things Trump Organization right now. They had to make changes to their compliance program. They had to make changes to their accounting program. They had to make changes to their banking. All of the financial transactions are being monitored. And that's enough for 2 of the 5 judges. And the other two were like, well, there might be an amount of money in addition, but it has to go back for a trial. And the problem is we're never going to be able to go back for a trial because the guy's president. And so he'll get an automatic stay until he's not president any longer. So that's 3 years from now, 3.5 years from now. So now the thing goes up to the United States. The thing goes up to the Court of Appeals, the highest court in New York. Just to screw with your mind, New York makes its top court, not the Supreme Court. And there's plenty for both sides to claim victory. It's 333 pages. It's 3 separate opinions. Nothing says this is ripe for an appeal to the highest court like that. And they know that. And so there's now going to be fight over the $500 million. Donald Trump's $175 million bond stays in place. This majority of the 5 decided that the stay should stay in place. They may reduce the amount of the bond for him, so he doesn't have. So maybe it's a $50 million bond. We'll have to keep an eye on that. And then it goes right to the Court of Appeals. And Donald Trump, even though he's in office, will have to pursue that. Letitia James said in a statement that she made that, they are comforted by the fact that the 4 out of 5 judges, the majority of that appellate court, found that there was fraud committed by Donald Trump and others in his organization. Michael Cohen is in there. I'm going to post this again, this 333 pages on Legal AF Substack for you to read. Michael Cohen's in there because when they were making the argument that Letitia James had no choice but to go after Donald Trump, it wasn't political vendetta. She had no choice because Michael Cohen in a federal matter had already testified out loud under oath that Donald Trump was fudging the books, cooking the books, changing the numbers on his personal financial statement. That's the heart of this case. That Trump wasn't satisfied being a billionaire. He wanted to be a 5-time billionaire. So he increased the value just out of the top of his head, out of the back of his butt. He increased the value of his triplex apartment in New York and of the golf course and in Mar-a-Lago and this property and that property. And then when you added it all up, suddenly he was in the Forbes, 100 list or whatever. And that he used that also to get out from under personal guarantees that would have been required if you didn't have that much money from a bank, and to lower the interest rate. And then he deflated the value of his property in order to save on taxes, inflation, deflation, all along the way. So that's the case. Next steps I've just given you. Last thing I want to wrap up here in this hot take. There is currently a vendetta, retribution, vindictive set of prosecutions that are aimed at Democrats. Pam Bondi and Donald Trump are leading it. They're using people like Bill Pulte, the Nepo baby who runs Fannie Mae and Freddie Mac, the mortgage entity, to make false claims against what appears to be false claims against the Senator Adam Schiff, Letitia James, and now Lisa Cook of the Federal Reserve. So having said all of that, they've opened up an investigation on Letitia James's Attorney General office for bringing this very case I just told you about under the grounds that it violated the civil rights of Donald Trump. So at least Moulton and Renwick took steps to disabuse any idea that this case was not brought in good faith. Here's what he had to say about that. He said, Presiding Justice Renwick and I found that Judge Engoron correctly found defendants liable. That's for fraud. We agree with the lower court that the Attorney General acted well within her lawful power in bringing this action and that she vindicated a public interest in doing so. We also found the lower court properly ruled on claims that were timely. However, we would modify the remedy ordered by the lower court, the Supreme Court, and we would make it an injunction only. That's the rub. That's the fight. We'll continue to follow it all right here. Take a minute. Go over to Legal AF Substack. I posted that. I've got an amazing live Substack that I just did today. Substack Live. I just did today with Michael Cohen about this, and Michael Cohen testified about was a witness in this very case. I mean, you had a lawyer who practices in that courtroom talking to a witness in the case, only on Substack Live. Come over there, and we have it up there right now. And while you're there, if you can swing it, become a paid member. It's about $8 a month, or at least a regular unpaid member of Legal AF Substack. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF. and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.